Well, we're here for a special meeting of the Board of County Commissioners in conjunction with some city council members who we believe will be joining us shortly, and with a member of the Town of Snowmass Village Council, John Wilkinson. The purpose of this meeting is Bob brought us, and with Bob brought us. Anyway, we're here for basically a reaffirmation of the Bill of Rights. We have passed a Bill of Rights resolution, or at least we have drafted one, which we will probably vote on again tonight. But we are here basically to reaffirm our oaths of office as public officials in support of the Bill of Rights and the Constitution. The reason that we've had to do this is that many of us are upset about the usurpation of the rights established under the Bill of Rights and the Constitution by current administration practices, including but not limited to the Patriot Act. And since the inception of this process and this public hearing process, there have been further proposals to codify the treatment of so-called enemy combatants in a way that would further deprive them of their rights to hearing and their rights to have at least some sort of fair tribunal on the basic issue of guilt and innocence. As we all know, there are quite a few prisoners being held by the United States without recourse to any kind of civil procedure, and the dispute in the Senate, unfortunately, is whether to continue this treatment or to certify a process that would essentially allow the president to designate people as enemy combatants without further process. So that's why we're here, and we have a number of people from the public who are going to be witnesses on some of these abuses. I think it's worth noting before we go to our first witness, that the American War for Independence, sometimes called the American Revolution, but actually a war for independence, originated from something called the Committees of Correspondence, which were municipalities and local governments communicating on the abuses of the British occupation, you might call it today, but the British rule of the colonies. And the communications of the Committees of Correspondence ultimately resulted in our first gathering and our first resolution for an independent nation, and ultimately our constitutional convention and the present form of government we enjoy today. But the role of local government in pointing out these abuses and pointing out the need for reformation of the system is not something that should be easily underestimated. Local governments are uniquely close to the citizens. We don't, unlike federal representatives and even some state representatives, we don't spend time away from our electors serving in an isolated capacity. We have direct, everyday contact at the grocery store, the bike shop, the bike race where I should be tonight, and other places, so that we have immediate contact. And sometimes we're the first to understand when things go wrong, because we are not insulated by lobbyists and people, paid staff, telling us that we're doing the right thing. All that having been said, maybe been said at too great a length, I would like to introduce Dwight Shellman for some discussion of this issue. Dwight? Make such a motion.
I move to open the special meeting.
Motion Clapper, second by Owsley. All those in favor so signify by saying aye.
Aye.
None of the rest of you are burdened by the need for a special meeting. Dwight.
I want to, my name is Dwight Shellman. I'm an attorney, former county commissioner, and I'm appearing today at the request of the Woody Creek Caucus, which provided you all with a early resolution requesting this hearing and the reaffirmation of the oath. My purpose in briefly introducing this subject is to remind us that this hearing is in the mainstream of American constitutional thought. And we are involved in what I hope is a teachable moment. Every generation is called upon to reaffirm the constitutional roots with which this country began. And I don't think many current modern people recall that the Constitution actually was not going to be adopted until the states received and the people received the assurance that the Bill of Rights would be added. And that's why it's an amendment or an appendage to the Constitution, because it wasn't in there in the first place. And among the rights and interests that were to be protected had to do with, or were, the assurances and guarantees against unreasonable searches and seizures, which today include things like surveillance without a warrant based on probable cause or other interference that's not related to an individual's attempt to commit a crime. The reason those were the initial amendments or additions to the Constitution is that the people who organized the country and the citizenry were keenly aware that the King of England had a program called the Star Chamber, which included secret trials of those believed to be seditious, and the King of France used letters of cachet, I think they were called, to stash people away in jail secretly without cause, and that those kinds of abuses had been claimed by monarchs before and since, and the American citizenry simply wanted to make clear that its own federal government couldn't engage in that kind of activity. No sooner did President Adams take office, our second president, and the Federalists passed an Alien and Sedition Act, which made criminal saying bad things about the president, for example. And many of the circumstances that surrounded that we find parallels in today. That is not to say that terrorism and the security of the United States are not important. They are important. And we have found over many generations the way to balance our own protection of security and maintain the security provided by the Bill of Rights. So today we're going to have yet another generational discussion in an atmosphere of alarm and legitimate concern about security as to why it is that our Constitution includes these guarantees against unreasonable searches and seizure, the right of the press, free press, the right of free assembly, and the right to petition, and the right of free speech. In order to kind of set the framework, I have provided the Assistant County Manager and the Clerk of the meeting with a copy of an American Bar Association letter to the President Bush, February 13, 2006, wherein the President of the American Bar Association, which is the leading American legal association, prestigious association, that requests that the President review the report of a select committee to address the issues and concerns regarding the program of domestic electronic surveillance conducted outside the FISA process, the Foreign Intelligence Surveillance Court. That committee of the ABA included a former director of the FBI, a former general counsel for the CIA, a former general counsel for the National Security Agency, former chairs of the ABA Standing Committee on Law and Security, and former federal prosecutors and others with expertise in national security. The report of that committee calls on the President to abide by the constitutional system of checks and balances and respect the roles of Congress and the judiciary in protecting national security consistent with the Constitution, oppose further electronic surveillance of in the U.S. for foreign intelligence purposes that do not comply with the FISA Court and the FISA Act, and urges the President, if he believes that FISA is inadequate, to seek amendment, but more importantly, urges Congress to step up and assume its role of oversight. That report was nearly unanimously approved by the House of Delegates of the Bar in a series of resolutions that said that the President did not have the exceptions that he claimed, and furthermore that the authorization to go to war with Iraq, being generic, did not provide him with that authorization, and again calling on Congress to step up and assume its responsibility. What's happened what's happened in our state is that in the spring of last year, our legislature, our Senate and House of General Assembly of Colorado passed Resolution 05-044, a joint resolution of both houses of the U.S. Or of the state government, basically indicating that certain provisions of the U.S. Patriot Act, that is also in the record, are inconsistent with the rights and liberties guaranteed by state and federal constitutions, and our state constitution, as you know, also includes the same Bill of Rights, and then proceeds to indicate that in accordance with the policy of the state of Colorado, no agency or instrumentality of the state, and that includes local government or libraries, should, without reasonable suspicion of criminal activity under Colorado law, initiate, participate in, assist, or cooperate with any inquiry, investigation, surveillance, or detention, a broad statement, or record, file, or share intelligence information concerning any person or organization, including library, lending, and research records, books and video store sales and rental records, medical records, financial records, student records, internet mail, and usage records, or other personal data, even if authorized under the U.S. Patriot Act, or nor should those instrumentalities of state retain such intelligence information, and that no agency or instrumentality of the state should collect or maintain information about political, religious, or social views, associations, or activities of any individual, group, organization, or business entity unless the information directly relates to an investigation of criminal activities and there are reasonable grounds to suspect that the subject of the information is involved in criminal conduct or use race, religion, ethnicity, or other profiling. And so we have a state legislature that has laid out its concerns about excesses under the Patriot Act or similar anti-terrorist legislation. And so our purpose here today is to allow us and the community to share with you the concerns and the gray areas that could arise where local government entities might be drawn in to questionable activities. To just give you a brief overview of that, I've invited Catherine Azuri, who is the Executive Director of the Colorado American Civil Liberties Union, who incidentally was one of the co-authors or at least witnesses supporting the state resolution I just read. And I've asked her to just briefly summarize some of the examples of what she's observed, keeping in mind that almost all of this is conducted under a cloud of secrecy. So I'd like to introduce Catherine Azuri.
Thank you, Dwight. Thank you, commissioners and city council members. The ACLU of Colorado undertook to support the state resolution because we have one client, and that client is the Bill of Rights. We support the Bill of Rights. We protect and extend the rights guaranteed under the Bill of Rights to all persons in Colorado, and that is our mission. I can tell you briefly with respect to the Patriot Act that the Patriot Act was passed in 45 days after the 9/11 terrorist attacks. Hardly anyone read it. It was drafted hastily. It was passed hastily. And because of that, there are some serious concerns by the ACLU and others with respect to the damage that the Patriot Act does to the rights of Americans, of people in the United States. One thing, too, that you should know is that when it was reauthorized this year in Congress, you may have heard that there were a lot of questions about how they were going to reauthorize it, whether it was going to be reauthorized. The problem was that once the reauthorization was close to happening, it again was done very hastily. It was again done without careful deliberation and concern as to the impact on the Bill of Rights and the constitutional rights of Americans. You heard Dwight talk about the FISA court. In the Patriot Act, the jurisdiction or the power of the FISA court was expanded dramatically. Now, how does that impact, or what's the effect of that with respect to local government? The FISA court is a secret court that is situated in the Department of Justice. That's where it resides. The judges, there's no adversarial relationship. There's not a lawyer for the person who's about to be subpoenaed or the warrant is going to be issued, and the lawyer for DOJ. Department of Justice goes into the FISA court and says, we would like a warrant or a subpoena, and we think it has something maybe kind of, sort of, to terrorism. The court grants them. The FISA court was originally impaneled in 1979 out of the church committee hearings, which dealt with the prior abuses of rights that were conducted by the FBI under the Hoover administration. So it was designed specifically to prevent the type of data collection and interference with constitutional rights that occurs. It is not doing that now. With the Patriot Act expanding its powers and with the secrecy that surrounds the court, DOJ can go in and get any warrant or any subpoena that it wants. The court has, in the last 3 years, granted about 1,200 such subpoenas and warrants. It has denied 3. So that should tell, I think that speaks to how easy it is to get those warrants. Now, how does that impact local government? If a warrant is requested for an Aspen or a Pitkin County resident, the warrant would come from FISA. It would have been done in secret, and it would allow the government to come into a Pitkin County resident's home without telling anyone, without giving anyone a chance, the resident of that home, a chance to dispute the basis for the warrant. Just walk right in. And they do. And when you're not home, okay? It's that secret. And frequently they do this with the help of local law enforcement. So not only do you have a resident whose rights are being violated, but you also have the involvement of local law enforcement. The FISA court and the Patriot Act were designed to combat suspected terrorism. However, what we are finding, albeit by anecdotal evidence, because it's not something, since it is secret, it's hard for us to be able to pinpoint all the times that this is done. But what is happening is that local law enforcement, working with the FBI, has gone to the FISA court and gotten warrants or subpoenas for what is typically criminal activity, not terrorist activity. It might be drug dealing, it might be fencing, it might be any of a number of criminal activities, but it's not suspected terrorism. And this is done through what's called frequently done through the Joint Terrorism Task Force. There are task forces, and I don't know if there's one here in Pitkin County or not, but the FBI, working with local law enforcement, has a relationship. Usually 1 or 2 members of local law enforcement are assigned to the Joint Terrorism Task Force, and they work with the FBI. We had a situation very similar to that, well, actually identical to that, happened in Denver. The Joint Terrorism Task Force, it was discovered out of the spy files cases in Denver, where Denver police were actually collecting information on law-abiding citizens who were protesting or demonstrating, Rocky Flats, the Yampa, whatever it is, a number of different issues that were hot topics. And so, excuse me, what we found as well is that the police were working with the FBI and collecting, after they promised they would not do that again, they were working with the FBI and collecting just that kind of information on peaceful demonstrators. The Denver Police SWAT team, along with the FBI, prior to the 2004 political party conventions, visited the homes of persons who were volunteering with the American Friends Service Committee, the Quakers. I mean, they're a really terrorist group, you know, and it's one of those situations. And people like Food Not Bombs, which actually prepared vegetarian meals for homeless people. They would, with the SWAT team, appear at these people's homes and intimidate them, ask them about whether or not they planned any criminal activity in New York or Boston, where the political conventions were being held. First of all, how did they know these people were involved with those organizations? Secondly, why did the Denver SWAT team participate? These are the kinds of implications for local government that really makes it important that you, as the governments of the local contact for citizens, that you are aware of these things that are going on, that you can oversee and support your local law enforcement or your local library or whomever, so that these kinds of things are not done. One of the problems that extends beyond or includes the Patriot Act, the national security letters. A national security letter is something that the FBI issues on its own. Somebody in the FBI office is designated as Mr. or Ms. National Security Letter. And an agent goes to the national security letter person and says, I want a national security letter for Dwight Shellman's records at his bank or his library or whatever. And he goes to the library, and the national security letter is given to the librarian, and the librarian has no ability to dispute that letter, has no recourse but to hand over Dwight Shellman's records of what he's checked out of the library. These are not, and it doesn't have to prove anything with respect to terrorism.